The case is now being recorded. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Thank you. Good morning, everyone. Welcome to the Appeals Court. This is our first case on the list today that we are hearing by the Zoom video platform. We will be hearing the remaining cases in the courtroom. Let me introduce everyone. My name is Amy Blake. I am very fortunate today to be sitting with Justice Grant and Justice Smith. We are the panel for the three cases on our list today. I am going to call our first case, which is MACKIE versus Mitchell et al., docket number 22P169. Mr. MACKIE, you are the appellant, so you may begin.
Good morning, Your Honors. My name is George MACKIE, and I am the pro se plaintiff in this matter. This case is all about the prison conditions I was subjected to while being civilly detained at the statutorily named Mansick Correctional Center, pursuant to Mass General Law, Chapter 123A, subsection 2. No matter how far the defendants attempt to twist my complaint to fit their agenda, use irrelevant information to inflame or distract the court from the real issue, or insist that the facility is a treatment center, they present no evidence to the contrary. I was transferred to the Mansick Correctional Center on July 24th, 2018, after completing my criminal sentence, pursuant to the statute. On June 6, 2019, I filed a complaint regarding the conditions of confinement the defendants subjected me to. The conditions I was subjected to between July 24th, 2018 and March 24th, 2022 were equal to or worse than conditions I was subjected to while serving the criminal sentence. Those prison conditions include, but are not limited to, being confined with individuals serving criminal sentences from days to weeks to months to life sentences in the same units, blocks, and sometimes cells. Or those given jail credits on sentences imposed by a court, and other restrictions, as I mentioned in my briefs, rather than getting into them all right? They are all comparable to prison conditions and equal to punishment. Those also include the number of visitors that could be placed on an approved visitors list, which was restricted to 10. As with other medium security prisons, I was also limited in the number of outside contacts via telephone, which was 10. Limited to the other items on purchase from the canteen, and a plethora of other conditions, some of which violated my constitutional rights, as mentioned in my original and subsequent complaints in this matter. Conditions for civilly detained residents are required to be less restrictive, and I argue that in Jones versus Blanas, Commonwealth versus Knapp, and Commonwealth versus Major. A quote in Sharp versus Weston: the civil nature of SVPA confinement provides an important gloss on the meaning of punitive in this context. Because he was detained under civil rather than criminal process, an SVPA detainee is entitled to more considerate treatment than his criminally detained counterparts. That's also in Youngberg, 457 U.S. at 321 to 322. Therefore, when an SVPA detainee is confined in conditions identical to, similar to, or more restrictive than those in his criminal counterparts are held, we presume that the detainee is being subjected to punishment. Finding that Youngberg required that individuals civilly confined at a commitment center receive more considerate treatment than inmates at a correctional center in which the commitment center was located. The lower court failed to acknowledge several motions regarding the conditions of confinement, which forced the plaintiff, myself, to seek assistance from a single justice pursuant to Mass General Law, Chapter 211(3). Excuse me.
Mr. MACKIE,
Defendants
Mr. MACKIE, now that you're out, What is the remedy? What are you looking for? If we agree with you, what do you want us to do?
I want to be compensated for what these people did to me, and I want the rules changed.
When
They
you say
can't continue.
compensated, you're saying money,
Correct.
money damages. And how much are those damages?
I believe I put in for $1,500 a day for every day that I was detained.
Okay. Please continue.
Okay. The defendant's unsupported position that no punitive conditions are applied in the detention of the plaintiff is an opinion and a fabrication claimed by the defendants to mitigate any claims of punishment, and it should not be allowed as a defense in this court. In Reed v. Faulkner, states that prison officials may not pile conjecture upon conjecture to justify their policies. The conditions as described in my complaint and taken as true describe punitive conditions and were ignored by the ruling judge. Mass General Law, Chapter 123A, and several case laws prevent any punishment while being civilly detained prior to and subsequent to being found as a sexually dangerous person. The plaintiff, after a finding of sexual dangerousness in a lower court, had that determination overturned by the appeals court, and upon reevaluation, it was determined that he was not sexually dangerous, and he was released on March 24th, 2022. This is relevant.
Mr. Mackey, I could imagine that some people would say that that shows that the system worked, that you were released after you had review by this court, and it was determined that the petition was subsequently dismissed. Doesn't that, what does that mean? The fact that some would say the system worked?
That has no bearing in this case whatsoever, Your Honor. As far as I'm concerned, I was held in a prison. The other two that matter of being overturned is relevant in the two other cases that I have pending in that court. Because of the condition, that has nothing to do with the conditions I was confined in. What I believe you're talking about is why it was overturned. It had nothing to do with the conditions.
Okay.
All set?
Yep.
Okay. This is relevant in that the conditions of confinement the plaintiff was subjected to were an extension of his criminal sentence and not supported by an indictment or presentable facts. 30 others are subject to similar condition, filed motions to intervene, all of which were dismissed due to the rules of court regarding representation. However, a motion for class certification and appointment of class counsel were ignored, nor were the others given the option of representing themselves. Several of those individuals continue to suffer from the same prison conditions and rules.
But Mr. Mackey, we're only here on your case. So if you could limit your remarks to the impact for you, okay?
Right. Well, those were part of the 30 interveners, part of this case, which were dismissed.
And today we're only here for your case.
Okay. All right. Several other motions, including a motion to preserve video recordings, were ignored by the court, denying the plaintiff an opportunity to be heard or present additional evidence of illegal conditions. One specific condition was the presence of staff with canines outside of the dining hall, clearly a prison condition. There is no difference between the conditions I was subjected to while serving a criminal sentence and the conditions I was subjected to while civilly detained at the Manskett Correctional Center. Therefore, the plaintiff was held beyond his criminal sentence without indictment, a violation of his constitutional right. If it has prison rules, prison regulations, and a prison setting, it's a prison. The defendants have allowed punitive conditions to exist once again after the removal of the federal consent decree, which was in place for over 20 years. However, Judge Mazzone stated that any individual may challenge his conditions of confinement by simply filing a complaint, and that's in King versus Greenblatt. Whereas the plaintiff has clearly outlined violations of his constitutional rights and conditions in violation of statutorily defined and common law conditions throughout his complaint by all the defendants, the judge's decision to dismiss the plaintiff's civil complaint in favor of the defendants was an abuse of discretion and should be overturned. The case should be returned to the lower court and the plaintiff and all previous potential interveners allowed class action status. Thank you for listening to the actual facts and reasons for the actions taken by the plaintiff.
Let me see if my panel members have any questions. I don't see any, Mr. Mackey. Does that complete your presentation?
Yes, it does, ma'am.
Okay, wonderful. I'm going to ask you to put yourself on mute now. Attorney Murray, when you're ready.
Good morning, Your Honors. May it please the court, Mary Murray for the government defendants in this case. First, I'd like to address with the court what is and is not before the court. There are no appeals from the interveners or proposed interveners. There is no appeal from anything other than the motion to dismiss ruling by Judge Buckley. So for that reason, because none of those are mentioned in the notice of appeal, none of them are before the court. And even if they were,
since you filed, Rule 3 has been amended. Do you believe that amendment impacts your argument to that degree? It's made it a little less rigid.
no, because for a different reason. It would change it slightly, but for a different reason. Mr. Mackey doesn't represent the interests of the interveners, and he also hasn't briefed the class action matter, so it would be not applicable. They're still not before the court because it's a failure to brief.
But his other issues.
I'm sorry,
Not regarding the intervener or the class action, but the other issues that you're arguing aren't properly before us.
I don't think it changes my argument. However, moving on, also, all of the claims for declaratory and injunctive relief are moot. And because since Judge Buckley's decision dismissing the complaint, Mr. Mackey has been released from custody, as the court itself alluded to a few minutes ago. And this is not a case which I suggest to the court is capable of repetition yet evading review. First, the robust body of case law that the defendants have identified show that conditions of confinement claims about the treatment center routinely go to judgment and appeal. That having been said, also Mr. Mackey has been out of custody for over a year, so a declaratory judgment would have to be based on current conditions. So there's an issue of staleness, and then there's an issue of Mr. Mackey litigating what could affect the rights of others. As he's told this court in his motions to extend time, he's not trained in the law. He said that to the lower court. And as a result, that could adversely affect the rights of others. So it would be in the weakest form. And of course, there can be no declaratory relief against Governor Baker, as he was the governor at the time of this matter. Turning to the substantive due process claim, and I might add one other point. He has no future interest in the facility because he's been released. So there would be an issue of ripeness involving Mr. Mackey raising claims. But a complaint, in order to withstand dismissal, a motion to dismiss under Rule 12b-6, has to identify who did what to whom. In the combined amended complaint, which I think was the third or fourth version of the complaint that the Superior Court allowed Mr. Mackey to file, when he had made several motions, there was a hearing, and the judge who heard that particular motion invited him to put and directed him to put one combined complaint, put all of your claims together, and that's what's before the court here. He identifies the defendants, says in some capacity you're in charge of things, and then doesn't connect the particular allegations to the particular defendants. And the case law is very clear. You can't merely lump all of the defendants together. The allegations about there are rules that apply in prisons that apply at the treatment center are not the question. The question is whether the conditions are reasonably related to the nature and to the purpose of the confinement. And the federal courts and some of the courts in the Commonwealth have repeatedly upheld the application of visiting regulations, telephone regulations, use of shackles, all of these conditions to this population. We are talking about, as this court itself referred to, a particularly menacing subset of sex offenders. The interest in security is quite evident in the statute, which is they're committed under Section 2. The Commissioner of Correction must run a facility or at a branch of the treatment center, within a DOC facility for the care, custody, treatment, and rehabilitation of offenders. And that interest in custody, as the federal courts particularly have said quite recently, in the consent decree and then in subsequent litigation, Healy against Spencer, that a failure of security would impair the rehabilitational environment itself. It would impair the ability to deliver rehabilitation services. So
what do you say, excuse me, what do you say in response to Mr. Mackie's argument that it is a violation of his constitutional rights to house together people currently serving criminal sentences for sex offenses with civilly committed SDPs?
So it is not a violation of any constitutional right for this reason. The people that were continuing to serve criminal sentences were also held on civil process, the SDP process, either as temporary detainees or as people who had been committed under a prior version of Chapter 123A, which permitted commitment under then Section 5 or Section 6, either at the time of sentencing for sexual offense or while serving a criminal sentence, and then the sentence would run concurrently. And the other part of this is we must look at the current statute for new initial commitments. And I particularly invite the court's attention to Bruno, where very early on, of course, the new commitment provisions were challenged. And in Bruno, the Supreme Judicial Court looked at that and was concerned about the pace at how these things would proceed. And the statute requires notice to the district attorney and attorney general 6 months in advance. And then the district attorney or the attorney general at the DA's request may file the petition. The SJC signaled in Bruno that you want these things to proceed so there's minimal delay. The probable cause hearing has to be within ordinarily 10 business days, once of a temporary order of commitment. Once probable cause is found, then the person shall be transferred to the Massachusetts Treatment Center for evaluation by qualified examiners. The hope and the goal is to get these things completed to the extent possible before the sentence expires. So there's nothing in the statute that prohibits the transfer of somebody who is in the last waning months of his sentence to the treatment center for the SDP process. And to suggest otherwise would require that, would A, interrupt the statutory mandate, and B, contrary to the SJC's clear intent in Bruno. This is not a situation where Mr. Mackie was placed with, and you see in the defendant's record appendix, addendum, it's not a situation where Mr. Mackie was placed in the side of the treatment center, which houses only people who are serving prison sentences, who have the opportunity to participate in the voluntary sex offender treatment program. He was placed in the civilly committed section, and he was there with people who were under civil process. So there's no constitutional violation. And the SJC has clearly indicated, as I said, that it would like to see these matters proceed with some degree of alacrity. So with that, there's no violation of his constitutional right whatsoever. With respect to his remaining claims, he doesn't identify any defendant, and B, he doesn't identify specific harm to him. So unless there are any other questions from the panel, the defendants urge the court to affirm Judge Buckley's ruling and send it back to the appeals court for an order affirming it. excuse me, the Superior Court. Thank you.
Let me check. I don't see any other questions, Attorney Murray. Thank you very much for your argument. Mr. Mackey, Attorney Murray, the matter is now under advisement. You will hear from us in the future in writing. Thank you both very much. This hearing is concluded and we will now rejoin the court.